of TCC Judgment 112 宪判 14, case on the recusal of judges in retrials and appeals of criminal cases. High notes. Article 17, subparagraph 8 of the Code of Criminal Procedure, which requires judges to recuse themselves if participated in the decision at a previous trial of the same case, is constitutional. The term previous trial should be interpreted as the decision at a previous trial of a lower court, and does not include the situation where the judge had participated in the decision at a previous trial of the same instance before being quashed. Within this parameter, JY interpretation number 178 needs no supplementation. In situations where the retrial or extraordinary appeal judges have participated in the previous final decision of the same case, the Code of Criminal Procedure is unconstitutionally insufficient for lacking specific provision requiring the judges to recuse themselves. Article 2 of Supreme Court implementational standards on allocation of civil and criminal appeal cases quashed twice previously, and Article 9, paragraph 1, subparagraph 1 and 2 of Supreme Court's implementational standard on allocation of criminal cases, and the resolution of S joint meeting of presiding judges of criminal panels of the Supreme Court of 1994, which stipulated that the cases that have been quashed thrice, and those that concern major crimes shall be assigned to the judge who previously quashed the cases on final appeal of the Supreme Court are constitutional. These provisions are internal standards stipulated by the Supreme Court under the protection of judicial autonomy and do not violate the right to judicial remedy. Supreme Court Criminal Precedent 29 Xiang 3276, which ruled that the judges at the first or second instance who have participated in previous trial are allowed under Article 7, subparagraph 8 of the Criminal Code to hear the case as a retrial judge of the same level after a higher court quashed and remitted the case is constitutional. The disputed precedent does not infringe on the defendant's interest in appeal under the right to judicial remedy. Background law. Background note. The case concerns the rule of recusal for judges in criminal procedure when it comes to retrials, appeals against retried cases, and extraordinary appeals. There are a total of 52 petitioners in this case, 37 of whom are currently on death row. One of the petitioners was petitioning on behalf of his two brothers executed in 2014. During the petitioner's respective criminal trial, retrial, or appeal, they were all faced with similar situations where the judges in the proceedings were the same as in the previous trial. Their situation can be classified into three main categories. A. Any of the retrial or extraordinary appeal judges has participated in trial of a previous instance. B. Any of the final appeal judge is the same as the judge who previously quashed the case for retrial. This happens when the case has been quashed twice or when it concerns a major crime. And C. Any of the retrial judge at the first or second instance has participated in previous trial of the same instance before a higher court quashed and remitted the cases. The petitioners filed for constitutional review respectively. They many argue that by allowing judges of a previous trial to participate in the cases in aforementioned situation, the following provision and the decision unconstitutionally violated the principle of lawfully designation of judges, due process of law, and consequently infringed their right to a fair trial and judicial remedy. The petitioner from 52 petitioners were consolidated. The TCC held a public hearing and summoned related party for opinion on October 24, 2022. The briefing was attended by attorneys of 3 of the petitioners, representatives from the Supreme Court and the Criminal Department of Judicial Yuan. Summary of the judgment holding. 1. The part 1. The term where the judge had participated in the decision at the previous trial in Code Provision 1 should be construed as where the appellate judge of the same case had participated in the decision of the case at the previous trial of a lower level, and does not include the situation where the judge had participated in the decision at the previous trial of the same level before being quashed. I read it again, this is important. The term where the judge had participated in the decision at the previous trial should be construed as where the appellate judge of the case had participated in the decision of the case at the previous trial of a lower level. So the term where the judge had participated in the decision at the previous trial. The term where the judge had participated in the decision at a previous trial should be construed as the decision of the case at the previous trial of a lower level, and it does not include the situation where the judge had participated in the decision at the previous trial of the same level before being quashed. So long as the provision is construed as such, it does not violate the protection of people's right to judicial remedy under Article 16 of the Constitution. JY interpretation number 178 needs no supplementation or adjustment within its scope. Part 2. Retrial or extraordinary appeal judges should recuse themselves if they had participated previously in the final decision of the case. The Code of Criminal Procedure lacks the aforementioned recusal provision, thus unconstitutionally violate the protection of the right to judicial remedy under Article 16 of the Constitution. The competent authority should amend the code as appropriate within a 2-year grace period. Before the amendment, newly lodged case or case underway should be tried per the requirement of the judgment. Part 3. Standard of Provision 1 and 2 stipulate that when a criminal case was previously appealed and quashed thrice by the Supreme Court, that is, previously appealed and quashed thrice by the Supreme Court, it should be assigned to the last judge that quashed the case on the fourth and later appeals to the Supreme Court. The provision do not contradict the protection of the right to judicial remedy under Article 16 of the Constitution. Standard Provision 2-2 and the decision of the Supreme Court Resolution 1994 provides that the quashed major criminal cases should be assigned on the later appeals to the judge that quashed it. The provisions and the resolution do not contradict the protection of the right to judicial remedy under Article 16 of the Constitution. The Supreme Court Precedent 1940 ruled that the situation where the retrial judge at the second instance had participated in previous trial of the same level before a higher court quashed and remitted the case does not constitute a ground for recusal because the trial are of the same level, which is different from the situation where the judge of the previous level joined the case on appeal. The President does not contradict the protection of the right to judicial remedy under Article 16 of the Constitution. So this is the basic understanding of the judgment 112 宪判 14 case on the recusal of the judges in retrials and appeals of criminal cases. The key point is that Article 17, subparagraph 8 of the Code of Criminal Procedure is constitutional so long as the term previous trial should be interpreted as the decision at the previous trial of a lower level, and it does not include a situation where the judge had participated in the decision at a previous trial of the same level before being quashed. And the second point is that retrial and extraordinary appeal judges who have participated in the previous final decision of the same court, of the same case, in this kind of situation where the retrial or extraordinary appeal judges who have participated in the previous final decision of the same case, in this kind of situation, the criminal procedure code is unconstitutionally insufficient for taking specific requirement to recuse themselves, to require the judges to recuse themselves. And then the third point is that Supreme Court's implementation standard about the situation where the cases that have been quashed thrice and those that concern major crime should be assigned to the judge who previously quashed the case on final appeal are constitutional. And this is internal standards stipulated by Supreme Court under the protection of judicial autonomy and do not violate the right to judicial remedy. The fourth point is that the Supreme Court Criminal Precedent 29 Shang 3276, which rules that the judges at the first or second instance who have participated in a previous trial are allowed to hear the case as a retrial judge of the same level after a higher court quashed and remitted the case. This kind of rule is constitutional, and it does not infringe on the defendant's interest in appeal under the right to judicial remedy.